Hello, this is Dan Marr, and today I'm going to be talking in this vlog about negotiating New Hampshire employment agreements, whether you're an employee or an employer. New Hampshire is an employee at will state, which means other than absent an agreement, you can be fired or quit with or without notice or with or without cause. So agreements might impact that. Usually, my representing employers, I always want to have the opportunity to fire somebody at my choice, at my client's choice, but there might be consequences to it. There might be a provision. If you're an executive, you might have a provision that says if you're fired or terminated without cause or with cause, there's two different situations. If it's without cause because the company decides that they can't afford to continue to have you, or there's other reasons that they decide not to go in a different, maybe they're going in a different direction of the company, but it's not based upon something that you've done that's bad, then they have to pay you an extra amount of severance. And you negotiate that in the agreement. If it's with cause, you've been committed of a crime of moral turpitude that's going to impact the reputation of the company. You've certainly taken some willful acts, like you stole from the company, or you padded your expense report, or you did something else there, or you lied to the company, or you did other things, or they told you consistently, you got to do these things. Maybe they are telling you you have to travel, and they said in the agreement that you have to travel, and you said, no, I don't want to travel. And so you're consistently insubordinate and you're breaching the agreement. In those situations, it's with cause, and if they're letting you go, they're not going to pay you the severance for that. So that's something that you negotiate usually through your attorney. In regards to that, it makes sense to do so instead of trying to do it on your own. For smaller level positions, you're probably not going to have that, but New Hampshire does require that the employer has to tell you in writing what your compensation is and what your benefits are. So they'll explain it to you in a minimal and in a letter. So you should look at that. They should be providing that to you in a letter. As to if you have commissions, specifically the details of those commissions, you can have real trouble if you don't, as an employer, if you don't spell that out, including how's it earned, and what happens when they quit or they get fired. Is there a difference between how they get paid? Do they get paid a couple of months later when the payments come in? All of that type of issues should be spelled out in their commissions. And you don't have to have it as an agreement, but you have to give it notice to them. That's New Hampshire law, and you have to follow that law. So those are important to be in a writing, even if you don't have an agreement. Another part of the agreements that happen, and sometimes it's the only part of the agreement, is a confidentiality, non-disclosure, invention provision, and also called non-solicitation, non-competition. The confidentiality, non-disclosure, invention stuff is don't steal our stuff, is basically what it is. It's basically saying when you're doing work for us and you invent something, it's ours. Confidential stuff you don't take to competitors, and you don't talk about it in social media. And all of that stuff is going to be strictly enforced. There's something called the non-compete, though. A non-compete is actually a provision that says you can't work in this industry after you leave. If that's part of the provisions, you should really seriously consider the law in New Hampshire, which traditionally, depending on the situation, doctors, nurses, and NPs can't even have non-competes under statute. But in New Hampshire, we will only enforce them if they're provided to you, the actual contracts provided to you before you accept the job. That's a requirement under New Hampshire law for that's non-compete. And then the other part of it is it legitimate for the business interests of the employer? And I'll tell you that most situations, other than like if you're a radio or TV host, most situations the courts are going to say, if you're in sales, your customers have to stay with the company. That part of the non-compete is going to be enforceable. The idea of the rest of the customers that you never had any contact with, or the industry, they're not going to enforce. They're going to narrowly construe that usually to say that the goodwill of the employer is protected by you not being able to go to that same customer that you went to while wearing the hat of the employer and pitching a sale to them. So that's going to be the issue. Non-solicitation, similarly, don't take our customers. Non-solicitation as to employees, don't take our employees with you. That's going to be enforceable.